Studio, we also have Sanjay Chadha, Advocate, Supreme Court of India, and Ashish Pandey, Advocate of the Supreme Court, joining us on this broadcast. Thank you all of you for taking time out to be with us here on Newsline. Brijesh, let me begin by asking you a simple question. It is that, a small difference between a stay on the act or the bill and a hold. Because even before a stay could come, there was a request that there was an offer to hold it.
Well, I think, if there was an interim stay per se, it would have been a more embarrassing by the government. And the government also felt, what was in the mind of this Chief Justice of India.
Right.
And as Mr. Chadha said, that the vibes of the Supreme Court were very, very clear to the government. And that is the reason why even before the Chief Justice could say something or decide on granting interim stay or something to the effect.
Right.
He said that the government itself promises that, for the next, till the next date of hearing, the government is not going to enact key provisions, and there's going to be no alteration as far as whether it's Waqf by land or Waqf by deed, or appointing non-Muslim members as ex-officio members in the board, or many other provisions. So basically the stay is there. The government has basically assured the court that we are not going to move forward till the next date of hearing. So it's going to be very interesting to see what is the response of the government as far as to buttress home their point about why there should be no ban, and this bill, the petitions filed by they should be dismissed, and the other side would also file the counter rejoinder to why they feel that that the arguments put forth by the government does not stand bottom.
Right. I think it was the Solicitor General Tushar Mehta who called it harsh. Sanjay Chadha, do you think this was a bit of a harsh move by the Supreme Court of India?
No. This is not the harsh move. This is, as my brother has very rightly said, it is nothing but a polite way of, politely the government has accepted the stay. Otherwise, it would have been a very harsh step if, the government would not have taken it in that spirit. And okay, that's how Tushar Mehta has said in the court, and said that you don't know, to the court, he has said that you don't know what will be the repercussion if the stay is granted. So, on the other hand, I think this is how politely the stay has been accepted by the court, by the number one. And this is a very common practice. It is akin to stay. I'm telling you, there's no difference. It is akin to stay. Now the government will have to think 10 times to take any step. And so there is no question of taking any step in accordance with the new act. That is very clear. Number two, now, as I said earlier also, 5 petitions have been chosen. Out of those 73, bunch of those 73 petitions, 5 petitions are chosen, in which the government will file the reply. Even the state governments where they are party, they will also file the reply. And these 5 petitioners, the option is given to all the petitioners to select these 5 petitions. These 5 petitions will file the reply to the reply of the government, and then accordingly thereafter the 1, 2, 3, 4, I don't know how many dates will be there. The best part would be that it is the government has also proposed that it should be a day-to-day hearing. So this stay, the statement of the government is recorded that they will not act upon it, especially 3 important provisions. One, Waqf by where registered and notified properties are there, they are already registered and notified, there will be no action. No new appointment, whether in the central Waqf board or at the state level, no new appointment will be given. This is a specific statement given by the legal officer of the government. So I don't think there is it is anyway less than any stay. It is akin to a stay, I feel so.
Okay, akin to a stay, nothing less than a stay.
Rejoined by the other party. It is a face-saving gesture, I would say, but it could have been, if the. But I agree with Mr. Chadha when he says that it's a normal routine legal practice. When you realize the judge is not in a mood to grant you any kind of relief, you immediately take the side B and say that I assure you that we are not going to act till then. But yeah, it's a bit of a setback as far as the central government is concerned, and that is the reason why you heard Mr. Amanatullah Khan and also Asaduddin Owaisi, they're very happy. They're saying that they will go, they'll fight the case out, till the end. But if you look at the way, and look at the way the Chief Justice has said, he has not, dismissed the entire act. He said that there are certain provisions in the act which are very good, but there are certain provisions which need to be re-looked into. Right. So I don't see a complete or complete stay on the entire act, but yes, the government may have to modify certain acts.
Sanjay Chadha, the question I have to ask you is that you call it routine, but Mr. Tushar Mehta says it's rare that that a court takes action like this. It's not every single day that you see a bill that has been passed as an act with the requisite numbers in the Parliament finding a hurdle at the Supreme Court of India.
There are two limbs of your question. One, routine. I said that when a lawyer is, an order is going to be passed against him, he will say, please, we accept this much. So, face saving. That is what I was saying. And as far as this practice is concerned, yes, Parliament has passed the law. Parliament has given full consent. But we are governed by, not only by Parliament, we are governed by rule of law. We are governed by checks and balances. It is not, if at all a law passed by the Parliament is contradictory to the, it has provisions which are opposite to the basic structure of the Constitution, such law will be thrown away. Such provisions will be ultra vires to the Constitution. This is a very settled provision, settled principle. Keshwanandan Bharti, 13 judges. Now nobody can change that. We have a very established law that we are governed by checks and balances. So here, if a Parliament passes a law, that law is somewhere contradicting the basic structure of the Constitution, like violating the fundamental right, and so on and so forth. Those things are there, then what will happen? The Supreme Court has a power to struck down those provisions, and Supreme Court has a power to remove those provisions. If you want, I can give you an example also. The example of this, the cyber law, where Section 66A was removed by the Supreme Court. That this is to the Constitution, more specific, Article 19(1)A. 19(1)A very specifically gives you right to, freedom of speech and expression. And that section 66A used to violate the freedom. So the court struck down such provision. Very much within the ambit of the power, and this has happened not once, several occasions we have seen the Supreme Court striking down provisions of law which are ultra vires to the Constitution.
Not the first time, will not be the last time, isn't it, Mr. Ashish Pandey?